Everybody, and thank you very much for joining us this evening. I'm delighted to be joined for a touch of glamour by Dr. Farnan, one of our senior MLAs, and Ms. Bansari Patel, one of our senior solicitors. And what we're going to talk about are talk about changes in death certification, the medical examiner system, which is changing, and of course the coroner system, which is what this talk was advertised about particularly. They all interlink one into the other, so it's important that we cover all of these things. There are some changes taking place, particularly in the first two of those things, that you need to be aware of. Be grateful if you could put any questions into the question box in GoToWebinar, okay? And we'll do our best to address them at the end. Just to put it into context, we have about 1,000 attendees on average in these talks. We certainly can't address all the questions, but we will try and address as many as we can at the end. Got one more caveat to that as well. Ed and myself do a lot of answering questions on the phone line. Bansari, as a solicitor, will tend to see lots of documents and get them all in detail to understand the details of things. So there may be some questions that come up that Bansari doesn't feel comfortable answering because she doesn't have enough detail. And we don't want to mislead you about things. So if you've got any specific or complicated questions, please do open a file or give us a call on the advice line so we can talk you through how to approach things. I'm going to send, or the team are going to send out some resources at the end of the talk. Well, it'll be tomorrow actually. So please don't fret too much about taking notes. And I've got some QR codes on a slide during the talk, which I'll leave up for a minute or so to allow you to get access to some relevant resources for you to use for your reading. Okay, hopefully a lot of it will be quite relevant to you. At the end of the talk this evening, there's going to be an opportunity to give feedback. If you could do that, it'd be very helpful. That will result in you getting your attendance certificate, which you can keep for appraisal processes and similar. Okay, so without further ado, let's move on to the first slide. A famous poet said that death is nothing at all. It doesn't count. It's often said at funerals, a poem we hear quite often. But as you know, as doctors, there are a number of issues that mean death does count. And we need to be aware of how that can impact on us as professionals. So I'm going to talk about some of the changes that are impacting doctors in England and Wales. And Bansari is going to talk about some of the important points to remember if you have to attend a coroner's court. Ed is going to sit in the background and put together all the questions for us. Apologies if you've joined us from Scotland or Northern Ireland. This information doesn't apply completely there. Now, there are some similarities in Northern Ireland, but Scotland is really quite different. So I'm going to talk about the changes in the death certification process, and then I'm going to move on to the changes with regard to medical examiners, and then that will lead on to naturally to coroner's inquiries, and that's where Ms. Patel will take over. So let's move on. So as you know, when a patient dies, doctors have got a duty to certify the cause of death, where possible, to the best of their knowledge and belief. Anybody, a family member, for instance, can declare a person dead, but it's a doctor's responsibility to certify the cause of death by issuing the MCCD. Currently, and this is right up to now, currently in England and Wales, the statutory duties to certify falls upon the doctor who attended the patient in their last illness. Now, there's no clear legal definition of attended, but it's generally accepted to be the doctor who cared for the patient during the last illness that led to their death, and so is familiar with their past medical history, their investigations, and their treatment. There were some changes during COVID, but that is how things are right now. The doctor particularly needs to have access to the medical records and the results of any outstanding investigations. As you will know, if the doctor has not seen the patient within the 28 days preceding death, and that includes video calls, and has not seen the body after death, the registrar of births and deaths is obliged to refer the death to the coroner. It is planned, okay, so planned, but we don't have the actual start date quite yet, that as of sometime next month, that particular requirement for 28 days will be removed, okay? And it will be changed such that a medical practitioner will be eligible to be the attending practitioner for the purposes of the MCCD if that doctor has attended the deceased in their lifetime. The attending doctor, again, will still need to be able to propose a cause of death for the MCCD to the best of their knowledge and belief. The aim of this is to avoid having a narrow pool who can complete the MCCD. So somebody goes off on holiday and they're not able to produce the MCCD. Anybody within the practice, for instance, should be able to do so, any of the doctors. And it also gets rid of that difficult situation when a patient's body has been moved far away, but nobody has seen them within the required period, and somebody has to take a trip out to a funeral home at some distance from the practice, which is often totally impractical, of course. The overall aim, like a lot of these changes, is to reduce the delay and consequent distress for families. But that's not the only change that is occurring. Once the new death certificate process comes into force, death certification process comes into force, again, sometime in April, all deaths in England and Wales will be independently reviewed without exception, either by a medical examiner or by a coroner. So, as you may know, medical examiners have been involved in reviewing death certificates for patients dying within trusts for some time. Actually, it's been expanded a bit more widely than that. In Wales, they were ahead of the processes in England. And this change that's happening next month means that they will have a broader remit to look at deaths in the community as well. In addition to these changes, there's also a new medical examiner certificate of cause of death, which I'll come to towards the end. But briefly, it's going to be a situation when the coroner can instruct the medical examiner to produce a medical certificate of cause of death. And these changes are all part of the new medical examiner process. Again, don't worry too much about the details. There is a slide coming up with the QR codes that will link you through to some guidance that you can read yourself. And of course, you can check our website for updates, and any concerns, you can pick up the phone and speak to us. So medical examiners were introduced in England and Wales in 2019. They were initially established on a non-statutory basis in trusts and the local health boards to review deaths in their organisations. Their role is to agree the proposed cause of death and the accuracy of the MCCD with the doctor completing it, discuss the cause of death with bereaved people and establish if there are any questions, so supporting the bereaved, acting as medical advisors for the local coroner, and identifying cases for further review under local mortality arrangements, contributing, if you will, to clinical governance processes. And that's much the same role that they're going to have when they're looking at deaths in the community. there's been a whole cadre of medical examiners trained through England and Wales to support the introduction of these new policies. It's long been established that following death, a case will either follow the path of medical certification by a medical practitioner, many of you will have done that, or investigation by a coroner. And that will remain the case from April, but with some important differences. Currently, as I've said, doctors have a legal duty to complete an MCCD and arrange for its delivery to the relevant registrar. Alternatively, if the doctor feels that the local coroner should be informed of the death, then they do that. As it stands, and as I said, medical examiners are currently scrutinising almost all deaths in acute trusts and a growing proportion of deaths in other healthcare settings, including the community. It's really become increasingly like a standard practice for medical examiners to provide independent scrutiny of deaths not taken forward for investigation by a coroner. However, prior to the introduction of this statutory system, medical examiner scrutiny is not mandated. In December of last year, draft regulations for the statutory medical examiner system, so one defined by law, were produced. And it is planned, as I've said, that in April 2024, there will be introduced mandatory review of all deaths in England and Wales. This will result in this independent review of all deaths without exception, which means that all deaths will be reviewed either by a medical examiner or by a coroner. So the new information flows will be as follows. Deaths that don't need immediately to be referred to HM coroner will be communicated to the relevant medical examiner. So I've put an arrow with two heads there because it's a discussion. It doesn't necessarily need to be a face-to-face or a telephone discussion, but an email communication, for instance, between the doctor who's going to be the certifying doctor and the medical examiner, the local medical examiner, discussing what their plans are for the MCCD. The attending doctor will propose a cause of death, and the medical examiner will provide independent scrutiny of that and discuss it with them and decide if it's appropriate. Once the relevant attending practitioner and the medical examiner have completed their declarations of certification and the scrutiny and the cause of death is confirmed, the MCCD is still sent over to the registrar. Alternatively, if the doctor feels that the local coroner should be informed of the death, then they'll do that. The statutory reasons for notifying the coroner are planned to remain much the same. And I'm going to detail them on the next couple of slides. So there's still going to be situations in which you as doctors will be referring deaths to the coroner. Medical examiners may advise the attending doctor to refer the death to the coroner, or may, probably quite infrequently, escalate concerns about deaths or patterns of deaths to parties able to investigate them. As I said, the statutory reasons for notifying the coroner are planned to remain much the same. So the statutory declarations are ones that were imposed on doctors by this regulation, the notification of death regulation. A duty to notify a relevant senior coroner of a death in certain circumstances. Regardless of how much time has passed, the duty applies unless a doctor reasonably believes it's already been reported to the coroner by another doctor, and reports by families don't remove the obligation. So, from Regulation 3 of that notification of deaths regulations, we have this long list of things that must be reported to the coroner. So just to highlight a couple of things on there, it's probably reasonable to mention use of a medicinal product. So we often see patients who have come to harm, potentially from intentional overdose or unintentional overdose from medicinal product. That would be an example of something that would have to be reported to the coroner. Similarly, violence and trauma or injury are fairly straightforward. Self-harm and neglect, similarly, these are situations in which the coroner must be informed, and the list goes on there. But the doctor suspecting the person's death was unnatural, but doesn't fall within any of these other categories, would be another catch-all category, meaning that the death has to be referred. But there's more. Despite taking reasonable steps to determine the cause of death, the doctor considers the cause of death is unknown. That's a reason for the patient to be referred. Similarly, they've died in state detention, so death in prison, death under the Mental Health Act, death in secure accommodation for young offenders. Those are amongst the things which would count as state detention. Not being able to identify the identity of the deceased person, another reason to do so. These last two are particularly relevant, I think, in the context of what we're discussing here. When the doctor reasonably believes there's no attending medical practitioner able to sign a certificate of cause of death. So let's imagine that nobody in the practice has attended to this patient at all. So it's a new patient who has died and nobody's seen the patient. Or that there's nobody available within a reasonable time frame. 5 days is what's put down as a reasonable time frame. In that circumstances, the coroner can direct the medical examiner to complete an MCCD if they are happy to do so. So, in other words, if the death is referred to HM coroner because there's no attending practitioner, there's no attending practitioner within a reasonable time frame, then the senior coroner can direct the medical examiner to produce a medical examiner MCCD. So, as I said at the start, I know there's a lot of information here, and actually there's quite a lot more information about this in the background, so I'm not touching on everything that is changing. For instance, there will be new electronic death certificates as well. But I'm not going to touch through everything because it'll just take too long to do that, and we don't have all of the details as yet. So I'm going to link to some of the resources on the next slide. So I'm going to take a bit of time for you to access those. I'm sorry, I was going to say that this medical examiner MCCD will be sent directly from the medical examiner to the registrar. So the GPs or the hospital officers don't get involved in that. Once the coroner directs the medical examiner, they send it on to the registrar. Anyway, as I said, here are some of the learning resources, and if you want to access these now or take a copy of these, then you can. The first one is for our e-learning. There's a lot of e-learning there that you can look at related to coroners. Then an overview of death certification from the government website, and then some information from NHS England about the National Medical Examiner system. A lot of the guidance on there, although it says it's from NHS England, which it is, the guidance in there will also apply in Wales, so it's broadly applicable. So you may want to look at that. I have tested them just before starting the webinar, and I know that they work. So once you've got those, we'll move on to the next slide, and this is going to introduce Bansari. So let's imagine the situation. One of your patients has died. The death was unexpected. The family blame you, and you're worrying that they may have a point. Or You may not why they've got a point, but equally, you know they're blaming you or they're blaming the practice, and you need to produce a report for the coroner. I'm going to give you a couple of very brief pointers on reports, but again, there's a lot of links in what I've sent you, in what you can get from those QR codes, sorry. You can link back to our guidance on writing a report. Whenever you're doing a report, you have to provide a clear, detailed, factual account based on the patient's records and your knowledge of the patient. It's advisable to only provide facts and refrain from providing an opinion. So you're not acting as an expert. Your opinion of what caused the death, I'll rephrase that, your opinion of the likelihood of any one cause is not really the issue here. It's really about your understanding of the circumstances leading up to the patient's death. Okay. Please note, and we still see this very regularly, it's not appropriate just to send the coroner the notes without including a report, or just direct them to read the notes, because the notes are written for doctors, for you and I. They're not necessarily written for the coroner. And the coroners these days, they're often not doctors. Do check what you're being asked to do as well, whether it's a report about your involvement specifically, which often happens in hospital, or if it's a summary report from the practice or from your team. If it's the latter, if it's not just you, you might want to show your report to your colleagues so they can check what you've said about their consultations, make sure it's accurate. If you're attending as a witness, so let's imagine we move things further forward. If you remember nothing else from this talk, and I realize there's a lot of information in here, please remember it's always worthwhile asking for us to look at your reports. We turn around reports really quickly. We can do it within the day. It's not a problem. And we can talk to you about your concerns. And whilst we can't give you clinical advice, I mean, I was a consultant surgeon. It's not for me to say the right thing for you to do as general practitioners or as different specialists. We can offer you an external view, and we can act as a sounding board for you. Because in circumstances like the ones I've outlined, where you have to go to a coroner's court, what we don't want is for you to end up being criticised by the coroner. That's because in that circumstance, you have to refer yourself to the GMC, which is a stressful prospect, really, for any of us. So we want to avoid that. And that is what my colleague Bansari is going to talk about. So moving the scenario forward, you've written a report, you know there are some concerns, you are an interested party, which Bansari is going to mention, which just basically means a coroner is aware that your acts or omissions may have contributed to the death, and you now have to attend the inquest. Bansari, do you want to take over?
Thanks, Jerard. I want to start by saying that I realise that for professionals, the thought of having your practice scrutinised and potentially criticised can be anxiety-provoking. And over the years, many of my doctors have said to me they're not sleeping and they've lost confidence. So for anyone who is currently involved or who becomes involved in inquest proceedings in due course, I've created a list of things that you can do to hopefully protect and optimise your position to reduce the likelihood of your being criticised. And I'm also going to cover what to do in the event that you are criticised. So step number 1, seek advice. And this should be your mantra. And seek advice early, because unfortunately, I've met many doctors who've waited until the week before or even the day before the inquest to seek advice. Ideally, as Jerard said, you want to seek advice before you submit your report or your statement. Drafting a statement is a skill, and a beautifully drafted statement will serve you well, not just at the inquest, but potentially beyond the inquest, and I'll say more about that later. A few years ago, I represented a doctor who, before contacting the MDU, he'd sent a very brief report to the coroner. It was probably only 2 or 3 short paragraphs. And essentially he said, I shouldn't have done what I did. It's my fault the patient died, and I'm really sorry. And the coroner disclosed that report to the family, who were understandably very upset and angry. And it was at that point the doctor contacted the MDU, and I met with him, and we sat down and we went through all the records in detail. And because he'd had the opportunity to reflect, he decided that in fact he hadn't done anything wrong and it wasn't his fault that the patient had died. Thankfully, we were able to rectify matters by submitting a further detailed statement, and happily the inquest concluded without any criticism of him, and I remember the family were very happy by the end of it. So the takeaway point is really take a moment to reflect before you write your statement, seek some advice, and also things can more often than not be resolved. So a few tips on writing reports and statements. First of all, bear in mind that most people who read your statement won't be medically qualified, so avoid using medical jargon, or at least explain it. I think it's really easy to be critical of a doctor if you're not a doctor and you don't have a full understanding of what they did, and more importantly, why they did it. So when you're writing your statement, think about your audience and gently guide the reader through what happened and why it happened. As Jerard said a moment ago, do keep it factual, but explain things. So for example, rather than saying her blood pressure was X, you might want to consider saying her blood pressure was X, which is normal, or which is slightly elevated, but not a cause for concern in these circumstances. Often when people make routine referrals, the family ask why it wasn't an urgent referral. So you might want to say, rather than I made a routine referral, I made a routine referral because her observations were normal. She looked well. She didn't meet the criteria for an urgent referral. Also, try to anticipate difficult questions or likely questions, and then weave your answers into the statement. So let's say, for example, you decided to refer a patient on the 10th of January, but you forgot, and the referral wasn't sent until the 10th of March. You might want to deal with that head on, rather than waiting for someone to ask you the question when you're in the witness box. And more importantly, you might want to say what you've done to stop that from happening again. And the advantage of that approach is it reduces your time in the witness box because your statement has already dealt with that question, and it eases the pressure on you. You're not sitting or standing there waiting for the dreaded question. Also, generally speaking, being open and honest from the outset will increase your credibility before the coroner. Jerard mentioned interested persons. So an interested person is someone who is entitled to actively participate in the inquest. There are different categories of interested person, which I won't bore you with for now. Sometimes the coroner will write to you to say you've been afforded interested person status. If not, you may wish to seek advice on whether you should request interested person or IP status. Having IP status conveys a number of advantages, one of which is that you're entitled to have sight of the other witness statements and reports, medical records you may not have seen, expert reports if the coroner has obtained any expert reports. It may be that those other documents contain inaccuracies or criticisms, and of course, forewarned is forearmed. Another advantage of having IP status is that it entitles you to ask questions of the witnesses, either yourself or through your legal representative if you have one. So if you don't have IP status, should you ask for it? No, not necessarily. Some feel it may make you look defensive or raise your profile unnecessarily. So it may be a conversation worth having with somebody if the coroner hasn't specifically said to you that you have IP status. So back to the list. Number 2, consider doing a significant event analysis. The advantage of this is that it gives you the opportunity to reflect, think about the case, think about the issues that might come up at the inquest. Coroners are used to seeing these documents, and in my experience, they often ask whether one has been done and they ask for a copy. If you do identify any shortcomings, then it provides reassurance to the coroner that the clinicians involved have reflected and that they've addressed or are addressing those issues. And if you don't identify any shortcomings, then it can be reassuring to the coroner to know that a number of clinicians have reviewed the case and they're satisfied that everything that should have been done was done. Number 3, consider doing an audit. So I had an inquest a few years ago where, owing to an administrative error, a referral had been missed and it wasn't made for a couple of months. And the GP practice undertook an audit which showed that within a defined period, I think 6 months or a year, the vast majority of referrals had been made within 48 hours. And where that hadn't happened, there was a good reason for that. And we decided to disclose a copy of that audit to the coroner to reassure them that this wasn't a common occurrence. So that's something that you might want to think about depending on the circumstances of your case. Step number 4, complete relevant CPD. So as you all know, there are many online and in-person courses that you can do. Sometimes it's difficult to find a relevant course if there's an unusual issue in your case. So in those cases, you can also read articles and book chapters, refresh your knowledge of relevant guidelines. If you do that, then you should keep a list of what you read and record the date that you read it, more importantly. Another thing you could do is review good medical practice. I have met a couple of doctors who arranged to meet with local specialists. So, for example, one doctor had seen a patient who presented with cardiac symptoms. They weren't referred to hospital and then they sadly died. And that doctor met with a local cardiologist, not to talk about the case specifically, and that's not something you should do, but just to talk generally about cardiac symptoms, when referral is merited and when it isn't. And the advantage of doing all of that is not only will it enable you to reflect on your involvement in the case, but it may also be helpful when you come to give evidence. Hopefully it will mean you're more confident, as you know you're up to date, you'll be more articulate when talking about the clinical aspects of the case. It will also stand you in good stead post-inquest if you are criticised, and I'll explain why later. Step number 5, revise, as if for an exam. You should know your statement and the medical records like the back of your hand, because it will make life easier for you and the coroner if you're able to find relevant passages within the medical records quickly. And it will also be easier to answer questions if you're familiar with your statement. But having said all of that, giving evidence is not a memory test. And you should have with you in the witness box a copy of your statement and the medical records to refer to whenever you need to. And there's nothing wrong with saying to the coroner, sir or madam, do you mind if I just refer to my statement? Inquests are public hearings, which means anyone can attend an inquest if they want to. If you'd like to attend an inquest, then I'd suggest you call the court, explain you'd like to observe an inquest, and ask when might be a good time to do so. The advantage of this is, I think sometimes we have this fear of the unknown. So if you go along to an inquest, then hopefully it will put you at ease when you come to give evidence yourself, as you'll be familiar with the process, with the format of proceedings, with the environment. And it can be really useful to watch others give evidence, not just in terms of what to do, but more importantly, what not to do. And I'm very lucky that for the most part, the doctors I've represented have been fantastic witnesses, but I've seen other witnesses be sarcastic, argumentative, overly defensive, arrogant, evasive, and it's really unattractive and it's painful to watch. So that brings us to step number 7, be an impressive witness. So when I interview doctors, I consider what sort of witness they'll make and whether they'll present as having or being the 3 C's, so competent, conscientious, and caring. Even if there have been shortcomings in your care, I think if you present as having these qualities, you're less likely to be criticised. Be well dressed. You don't have to wear a suit necessarily, but the smarter you are, I think the better it is. Answer the question, and I've put an exclamation mark after this because I think it's so obvious, but so many people don't do it, and I'm sure I'm guilty of it too. The difficulty is it may make you look evasive or irritate the coroner, which is obviously not what you want to do. So really listen to the question carefully, pause, and then answer. And I haven't put it on the slide, but don't ramble. So coroners are not necessarily medically qualified, so they may need you to go through things slowly. They may wish to make a note. I used to have a colleague who used to say to doctors before the inquest, he would hold up a pen and he'd say, if I ask you what this is, the answer is it's a pen. I don't need to know that it's yellow, that it's got some writing on the side, that it's over 10 centimetres. If I need additional information, I'll ask you another question. And it's a crude example, but I think the point he was trying to make is you need to find that balance between relaying the information that you want to relay and that you need to relay, but also not answering questions that haven't been asked as yet. Don't guess or speculate. So this can come back to bite you. Never be bullied into answering a question that you can't answer. It's absolutely fine to say, I don't know, I can't remember, I'm not sure. It may be appropriate to talk about your standard practice if you can't remember. So for example, I've heard people say, I don't specifically recall whether I asked her whether she was feeling suicidal, but it is my standard practice to ask that question whenever somebody presents with low mood. Some people, including lawyers, are terrible at asking questions. So if you don't understand the question, don't hesitate to say, can you please rephrase it or repeat it? A word about emotion. I've had quite a few doctors say to me they're understandably very upset and they're worried that they're going to cry during their evidence. My reply to that is always, if that happens, don't worry. Of course, you want to maintain a professional appearance and you don't want it to be suggested that you're trying to shift the focus away from the family. But crying during your evidence happens not infrequently, and of course it shows that you care and you've been deeply affected by what's happened. I'm also asked whether you should offer your condolences when you give evidence. You may already have done so in your statement, but if you want to do it when you give evidence as well, you can. So sometimes when you're asked your first question, you can say, before I begin, I'd just like to offer my condolences to the family. Or you might prefer to do it at the end of your evidence. So the coroner will usually say at the end, doctor, is there anything you wish to add? And in which case you can do it then. So if, despite having done the 7 things, you are criticised, what should you do? Well, the first thing is to consider whether you need to self-refer to the GMC. So there is GMC guidance on reporting criminal and regulatory proceedings within and outside the UK, and that says if you've been criticised by an official inquiry, and an inquest is an official inquiry, anywhere in the world, you must tell us without delay. Without delay isn't defined. I normally tell people to aim to self-refer within 7 days of becoming aware of the criticism. And if you're going to take longer than that, then make sure you've got a good reason. And then the guidance goes on to say, by this we mean that you must tell us if you have received criticism that relates to serious matters that could call your fitness to practice into question by the coroner. So that means if the coroner has made the criticism. Sometimes there's no clear answer. And if you ask 2 different lawyers, you may get 2 different answers. So that's why it's really important to seek advice. Where there isn't a clear answer, then often the prudent approach is to self-refer. Even where the criticism doesn't meet the threshold for referral, it might be tactically advantageous to self-refer, because if you don't self-refer, someone else might. So you might want to get in there first. So who else can refer you? Well, the coroner could, but I would expect them to warn you if they're thinking of doing that. There might be an aggrieved family member who decides to refer you. I once had a doctor who attended an inquest and they gave evidence. There was no criticism of them, but an anonymous member of the public who was present during the inquest wrote to the GMC about his concerns. Now, I've never known that happen before or since. It's extremely rare, and I have my suspicions that he was actually related to the family, so I wouldn't worry too much about that. I've also come across a couple of cases where there's been an article about the inquest in the press, and someone at the GMC has come across the article, and an investigation into the doctors mentioned in the article has ensued. Having said all of that, please know, and this is really important, just because you or someone else refers you to the GMC, it doesn't mean the GMC will necessarily open investigation. Okay? They might just write to you and say, thanks for letting us know, we don't propose to take any action. So how do you reduce the likelihood of a GMC investigation? Well, we know by now the mantra, seek advice. So seek advice on what to say in your letter to the GMC. You don't just want to notify the GMC of the criticism, you also want to tell them about all the learning and the reflection that you've done. So this is your opportunity to reassure the GMC by sending copies of your CPD certificates, by saying which articles you've read, which guidelines you've read, how you've changed your practice if you have. It's really helpful if you can show that you undertook the learning and the reflection before you were criticised. So hopefully the dates on your CPD certificates predate the inquest. If the GMC does decide to investigate, they may ask the coroner for a copy of your statement, which is why I said at the beginning, a beautifully drafted statement will stand you in good stead beyond the inquest. If you wish to disclose any inquest-related documents, then just ensure the coroner has no objection before you do so. A quick word about PFD, or Prevention of Future Deaths reports. So if the coroner is concerned that a risk of other deaths will occur or continue to exist, and in the coroner's opinion, action should be taken to eliminate or reduce that risk, then the coroner must report the matter to a person with the power to take such action. And a person or authority to whom the coroner makes a report must respond in writing within 56 days. So an example of this might be the coroner is concerned that there's no system in place for monitoring at regular intervals whether repeat prescriptions are being requested and dispensed, or maybe they're concerned that records are being kept in different places, so it's difficult to see everything that's happened in relation to a particular patient. Hopefully this doesn't arise because you followed the 7 steps and you've reassured the coroner already. But if it does, when responding, you must provide robust evidence that remedial actions have been taken and are underway within a clear time frame. So some words of reassurance. I'm conscious that talking about the possibility of being criticised and talking about GMC proceedings can be anxiety provoking for some. So I want to end by telling you this. Lawyers are a really pessimistic bunch, and I've represented doctors at plenty of inquests where I've considered them vulnerable to criticism, but where no criticism has materialised. And I've seen families who were initially very angry at the beginning, by the end, calm down, hug the doctor and thank them for all their help. I don't know what the wider statistics show, but in my own experience, when I've represented doctors who were criticised and have had to self-refer, in the vast majority of those cases, the GMC hasn't opened an investigation. So I've been doing this since 2009, and I can only think of 2, maybe 3 doctors who've self-referred and then ended up with a GMC investigation. So I hope this talk has left everyone feeling a bit more reassured and hopefully empowered. And to conclude, if you are invited to an inquest, don't panic, prepare, as we've discussed, and if you are criticised, know it's not necessarily the end of the world. And then I think there's a final slide as well with some contact details. And I think, Jerard, we're going to answer some questions now. And
thank you. We're going to try and take some questions now. So thank you very much for that, Bansari. I appreciate that. Ed, I think there were some questions I haven't looked. I've left you to do that. I'm sorry for asking you to do all that.
There have indeed. There's a couple of questions come in towards the end, and I think they're really directed to Bansari, more just to clarify something which you said more than anything else. And it was when you were talking about sort of CPD and things like that, about incidents which might have happened, you suggested that doctors might seek some advice from perhaps a specialist in secondary care, but not to discuss the case. So one person asked specifically, why can't they discuss the case, particularly if there was secondary care involvement in the case? Why can't they discuss the case with secondary care in that situation? And the other question is, what would the implications be for the doctor in secondary care who you speak to in general terms? Could they be asked to give evidence?
The reason why I said that you had to be careful about discussing the case is if you are an interested person, then documents are disclosed to you on a confidential basis. So it may be that you've been privy to information that shouldn't be disclosed elsewhere. So that's why it's generally just safer not to discuss the case. If you're meeting with somebody for CPD purposes, so to improve your own practice or to reflect on your own practice. But in certain circumstances, obviously, people do discuss cases together. So it really just depends on the circumstances of your case. And if you're in any doubt, then the best thing is to pick up the phone to your MDO and just check who it's safe for you to discuss the case with.
But I guess that if it's issues that you know about from the notes because you wrote the notes, and it's a discharge letter from the hospital setting out facts, and those are the 2 things that you might discuss, then that wouldn't be that unreasonable, would it, Bansari? Because you're not disclosing anything that you wouldn't know anyway.
Yes, there is a distinction between discussing the case with somebody involved in the case and discussing the case with someone who isn't, and you're meeting them for CPD purposes.
Right. Thank you. Ed.
The question for you, Jerard, I think somebody asked, will this new system of medical examiners and all deaths being discussed, will that apply to paediatric deaths as well as to adult deaths? I assume it will.
Yes,
all the other processes like sort of child death reviews will also still be in place, but
yeah.
So
it doesn't. So we're still waiting for a lot of the we're still waiting for some of the underpinning legislation to be updated. So there's still a little bit of fuzziness around some of the details, but the details do mention that children will be deaths of children will be part of that, and it won't impact on things that happen around deaths of a child, like the child death review.
An interesting one, which I assume I know the answer to, but I'd like your view, is what happens if a patient dies abroad? Where does the medical examiner system kick in there? I assume medical examiners will be involved in deaths which occur within their own jurisdiction.
Yes. So I don't think they'll be involved. Obviously, coroners are involved because the bodies are repatriated to usually to an airport within their jurisdiction, and then it becomes something that they may become involved in. Hence, some coroners may be particularly involved in military deaths because of the repatriation of military deceased to particular airports. But I don't think the medical examiners will specifically be engaged. Again, that's probably a situation in which if I was asked that question on the advice line, I'd rub my large bald head and suggest that people write in.
Indeed. Back to Bansari, if that's okay. Somebody has specifically asked that they're not quite sure that they understand what's meant by an interested person. Is it a person who's related to the case directly, or is it somebody just who's there to observe the inquest? So I think we expand on that.
Sure. So I think what I said in my slide is that an interested person is somebody who's entitled to actively participate in the inquest. And there are different categories of interested person. So if you are the partner of the deceased, the child of the deceased, you'll be an interested person. There are various other categories that you don't need to worry about. The two that I normally come across are if you may have caused or contributed to the death, and that's obviously a horrible phrase for a doctor to hear. Sometimes if the coroner affords you interested person status, it's not necessarily because they think you may have caused or contributed to the death. They may feel that you fall into another category, which is that they simply think you have a sufficient interest. So I think in practical terms, sometimes coroners aren't particularly worried about what the doctor may have done or may not have done. But if they know that the family is concerned, then they may afford them interested person status so that they have all the advantages that we've discussed. They can question witnesses, they can see the statements and the other medical records, and so on and so forth.
Somebody's asked an interesting question. What are your options? What can you do if you think that the conclusions arrived at by the coroner are incorrect at the end of the process? Is there a right of appeal?
That's if you think that the conclusion is unfair, then I would say definitely seek legal advice at that point. But generally speaking, it can be difficult to do anything about it.
Yeah. Another question which came up there, is it obvious at the outset, for example, if your first contact with the coroner is a request for a written statement, is it obvious at that stage that you will have interested person status? I think the answer to that is sometimes it might be, but generally not. And the request for a statement is the very start of the process. The coroner will keep that under review as the process goes on. And if criticism, for example, come to light from the family or concerns come from the family at that stage, or if the coroner identifies something on review of other statements or records, it's at that stage that the coroner will decide who is or who isn't an IP.
And that's really important, I think, to think about, because coroners' processes and their inquiries are dynamic processes. You may put in a statement 6 months before the inquest is due to be called, and the coroner may not read the statement until quite close to the inquest time. And if you're, and it might be that you've gone from just being a factual witness to them suddenly having a concern about something within your statement, and then their view of you changing. So it's always worthwhile, at least I think it is, to stay in contact with the coroner and close to the time, maybe just double check. Am I a witness, to a factual witness? Is that still the case? And the question is quite helpful as well, is has anybody been critical of my practice, or the practice's involvement with this patient? Anything else, Ed?
Sort of as an extension from that, a lot of questions come up just after you finished about this possibility of being criticised at the inquest and then having to trigger a self-referral to the GMC. Somebody asked what percentage of coroners' inquests result in criticism. I don't know that we can give a percentage, but it's a tiny minority. I would suggest it.
Well, I've just audited it, to be honest, from our data here, and it is a tiny percentage. It's roughly 4% or so from my sort of rough review of the figures. So it's not at all common. And as Bansari said, It's a serious issue that gives rise to questions about one's fitness to practice, and sometimes it can, if you're not sure about whether it does give rise to a concern about fitness to practice, then discussion with other people, not just the MDU, perhaps discussion with your responsible officer and saying, this has happened, this was the discussion, do you think that's something that would trigger me self-referring? I've said responsible officer there, and it's often something that doctors in hospital might do because they may have a closer relationship with their RO. And if you've got an RO who you've spoken to, who's recorded something about the conversation and says, no, I don't think so, that's quite a helpful thing. If somebody later says, well, you should have done that. If your RO has told you not to bother, then that's helpful. But I think Bansari was right that you're better to be cautious if there's any suggestion of criticism. But we all discuss it when we're not sure, which is quite often. We ask each other and we go around the houses saying, what do people think? Has this tipped over into enough criticism to self-refer?
Yeah, just to add, Jerard, obviously the cases that I deal with tend to be the ones where there are concerns that there's going to be criticism. And I would say the minority of my cases as well, where there is criticism.
Yeah. And we can often, as you said, a beautifully written statement can often work wonders. If you can address those criticisms or preempt them and anticipate them and address them, by getting that CPD in place and doing the changes to systems, that can work wonders in sort of preventing anything untoward happening. We sort of tried to anticipate some questions before we started, and certainly one of them has come up. What are your options if you're called to attend an inquest at extremely short notice, or how much notice should a coroner give you if he wants you to attend, bearing in mind that you're likely to have a fully booked surgery all of next week, for example?
Yeah, so because court diaries are so busy, coroners' inquests are often diarised weeks, months in advance. So I would expect everybody to have a decent amount of notice, but of course that doesn't always happen. And I have had a few cases where the doctor's been asked to attend at short notice. And it's not just that they've got a surgery booked, it could also be that they've arranged to go on holiday, they're due to undergo surgery, maybe they're due to sit an exam. So if you're in that circumstance, the best thing to do is to write to the coroner to say that you're anxious to assist, but unfortunately you are already on holiday or whatever. And it's also a really good idea, because if you don't, the coroner will probably ask for it, to provide evidence, say send a copy of your plane ticket or whatever. Generally speaking, I found coroners very willing to accommodate witnesses who have made other arrangements. And I think I can only think of one inquest where the coroner asked the doctor to interrupt their holiday to attend the inquest. That was pre-COVID, and of course things have changed now, and often you can attend inquests remotely. So that may make life easier if you have already got a fully booked surgery, for example.
But probably not with a strawberry daiquiri and a polka dot shirt from the beach. That's probably not the right thing to do. Anything else, Ed?
I think we're sort of touched on most things. A significant number of questions came in after we finished and after we started the chat. So I think, Jerard, you and I might go through those tomorrow and see if we can put something together for people whose questions we haven't answered. But I think we've touched on the big ones.
There was an article I was going to mention, I didn't put it into my talk. There was an article that Catherine Leask, one of our colleagues, did in Pulse. I think it was Pulse, it might have been GP Online, in January about some of these changes. And it talks about getting yourselves ready to set up communication links with medical examiners. I'm hoping that the ICBs have started those sorts of processes, and that your LMCs have communicated some of those communication pathways. There is legislation in place to allow you to share information with medical examiners. It's being clarified right now, but there is basic legislation in place to allow that to happen. So there shouldn't be any obstacles in place, but you may need to work on the local details of how you go about actually sharing information, to whom you should be sharing it. You may need to check those sorts of things locally. Should we call it a night there? Thank you very much, Bansari and Ed, for joining me tonight and giving your inputs, really helpful. Thank you all for coming in the evening to listen to us talk, and do come back and listen to us again if there's anything else that we can interest you with. Have a good night.